serious stuff going on before the Supreme Court this year. A number of cases that I just want to flag for you because we will be talking about them as the court goes through its docket, throughout the rest of this year and into next spring. Just to give you a heads up, the first is this case around the Consumer Financial Protection Bureau. It's called CFPB versus Community Financial Services Association. On its surface, this is a case about payday lenders. Basically, ripping off and exploiting average working people, and particularly our military, our soldiers. But 3 Trump-appointed judges on the U.S. Circuit Court of Appeals for the Fifth Circuit ruled that the funding structure of the Community Financial Protection Bureau is unconstitutional. The Constitution says that Congress has to appropriate funds for basically all government functions. And Congress did appropriate funds for the CFPB. It just specified that those funds, instead of coming out of the Treasury, would come out of the Fed. And the Fed has its own unique funding mechanism, as does the Comptroller of the Currency, and the FDIC, the Federal Deposit Insurance Corporation, all of those. So if these guys if the Supreme Court strikes down this regulatory agency, the CFPB, just because they want to go along with, what the banksters want, they're going to devastate, throw into total chaos our financial system here in the United States. So that's the first case. That's absolutely huge. Then there's Loper Bright Enterprises v. Raimondo, which could overturn the Chevron deference. The Chevron deference says that it's okay for Congress to say to a federal regulatory agency, say the Environmental Protection Agency, we, Congress, are telling you to clean up the air. And then the EPA goes out and hires a bunch of scientists and says, okay, where's the air dirty? What dirty air do we need to attend to? How do we go ahead and clean it up? And then they come up with a plan and, good science, and then they execute that plan. Well, what's happened here is you've got Republicans who have sued saying, no, wait a minute, that Chevron deference that the federal government can defer to the expertise of regulatory agencies is wrong. That if Congress wants to have the CO2 limits changed or the soot particulate levels in the air changed, they have to pass a law that specifically says that, rather than just giving the authority to the EPA, in this example, to come up with what the standards should be. In other words, instead of the EPA hiring scientists, individual members of Congress need to be hiring scientists. Instead of the EPA doing the research, Congress needs to do the research, which, of course, you and I both know is never going to happen. Congress doesn't have the time, the manpower, the wherewithal to do this kind of thing, which is why we have it done by regulatory agencies. But that's exactly why the right-wing billionaires are bringing this lawsuit to try to shut down these regulatory agencies and say, no, Congress has to pass detailed legislation telling you exactly what they're going to do, and with its own scientists, because they know it'll never happen. It's a way of destroying the regulatory state. What Steve Bannon said, the number one goal of the Trump administration was to deconstruct the regulatory state. So that's the second case. That's Loper Bright Enterprises v. Raimondo. Then you got Alexander v. South Carolina State Conference of the NAACP. This is a case where a 3-judge panel in January said that this district in South Carolina, this gerrymander, is unconstitutional under the rules of South Carolina and under the federal Constitution. In fact, they said that it was, quote, an unconstitutional racial gerrymander because the legislators had deliberately moved tens of thousands of black voters to a different district, making a district a safe seat for Republicans. There's another case around the Second Amendment. This is United States versus Rahimi. It's a challenge, which this is totally bizarre. The Republicans who brought this challenge to the Supreme Court are saying that it is unconstitutional for any government, state or federal government, to say that a man who has assaulted his wife and threatens his wife may not own a gun. They are saying that no, if a spouse is abusive, if a spouse has been violent, that spouse has an absolute right under the Second Amendment to own a gun and use that gun to kill his wife. The last part of that they don't include, but you know, that's where it's going to go. So that's U.S. versus Rahimi. And their rationale for this, by the way, is that because in 1789, when the Constitution was ratified, there was no such thing as a restraining order for domestic abuse, that men who are under restraining orders by their wives, or wives of their husbands for that matter, although it's far more rare, cannot be subject to restraining orders because they didn't exist in 1789. This is the logical consequence of the insanity that Antonin Scalia brought us with the Heller decision. And then, you know, there's the abortion case. This is the Alliance for Hippocratic Medicine versus the FDA challenging mifepristone. Now, the Supreme Court has not said for sure that they're going to take this case. And if they don't, then the availability of mifepristone across the country has been severely limited. And then, of course, there is a big tax case, Moore v. U.S., that could eliminate the ability of the federal government to charge taxes, income taxes, on foreign money that has not been realized in the United States. So lots and lots of stuff here. Clarence Thomas, has recused himself from one case, but none of these ones that have to do with finance and billionaires. And they're calling, Common Cause and other groups, are calling for Clarence Thomas to recuse himself from these cases that involve his billionaire donors. And he's saying, I ain't going to do that. These guys paid for me fair and square. And I'm not going to, go back on my deal with Harlan Crow and Paul Singer and these other guys, or at least it appears that that's essentially what Clarence Thomas is trying to say. He hasn't obviously used those exact words. Meanwhile, in North Carolina, when their state Supreme Court struck down the Republican gerrymandered maps, everybody thought, oh, cool, now North Carolina is going to end up, having a legislature and a congressional delegation that actually reflects the will of the people of North Carolina. But then they had an election, and the Republicans took control of their Supreme Court, and their Supreme Court just reversed itself and said, oh no, not only is gerrymandering fine, you can gerrymander even more severely than you have up to this point, which the Republicans in North Carolina are doing right now, which brought Eric Willoughby, a senior in high school in North Mecklenburg County, Huntersville, in North Carolina, brought him before the state legislature. And this is what he had to say. And I thought this was absolutely brilliant. This is how a lot of Zoomers are feeling right now. He said, I'm 17. I should be spending my Wednesday afternoons with friends or family, but instead I'm here with y'all. I'm here because every single day I have to worry about which liberties Republican legislators are going to choose to gut next. They started by refusing to take action against gun violence and destroyed your right to peace of mind about something as simple as sending your child to school. Then they came for your right to make the most basic reproductive health care decisions that were right for your family and you. This time they're coming for every North Carolinian's right to fair representation. Eric Willoughby goes on to say, 17-year-old Eric Willoughby, this legislature is made up of the same people who have drawn maps that intentionally disenfranchise and limit the power of historically marginalized and minority voters. These are the same people who have proven to us time and time again, through their voting records, that they don't care. If these people cannot be trusted to protect our basic rights, how can we trust them to draw fair and impartial maps that promote a healthy and vibrant democracy? They can't. We can't trust them. The Republicans in this committee and the others in the House and Senate don't care about democracy. They don't care about fair maps. All they care about are three simple things: re-election, power, and dollar signs. This redistricting stunt is a clear power grab by Republicans in the General Assembly, so I urge you now, watch your step. Be very careful in what you choose to do, because young people like me are watching, and young people like me are fed up. Oh, very interesting.